Yes, Your Honor. The parties have stipulated to restitution for Copper Point, which is the workers' comp. It was $187.10 the parties have stipulated to, and Attorney John Main is here on behalf of Copper Point. For Giligion's Bar, the amount is $613.18, and the representative for Giligion's Bar is Mike Phillips, who is also present. And that's the restitution that the parties have agreed on.
Is that the full amount of restitution?
Yes, Your Honor.
Is that correct, defense?
We agree with that, Your Honor.
Okay. Then that takes care of the restitution issue. Then we move on to the aggravation hearing. Does the state wish to present any witnesses?
No, Your Honor. No witnesses other than Mr. Kevin Picori. He may wish to make a victim impact statement, and then the state would like to make argument if permitted.
Okay.
Okay.
Sir, if you could state your name for the record, and please state whatever you wanted to state as to the sentence.
Kevin Charles Port, and Mr. Gionet kind of wants to make a name for himself, kind of be famous, and I just asked that maybe give him an opportunity instead of jail time to humble himself, apologize to the people that he antagonizes and maces, and then maybe get maced on one of his web streams. And pretty much all I gotta say.
Okay, thank you, sir. Anything else from the state?
The state would just like to make an argument, Your Honor.
Okay. Does the defense wish to present mitigation?
Yes, Your Honor.
Okay, please call your first witness.
Oh, thank you.
You are up here or up there, Your Honor?
I'm not witnessing. Will you raise your right hand?
Judge, I'm so sorry. I do apologize. I was confused. I do have my actual exhibits that I would like to introduce. I did file those with the motion, but I would like to actually introduce that as evidence and then play those during my argument. So I don't know if the court would like me to, how the court would like to handle that. I do apologize.
I've never seen that before. Does the defense have any preference? Do they want them played now or do they want them played during their argument?
Your Honor, the defense takes no position.
Okay, then it's up to you.
Okay, I'll play it during my argument and introduce those exhibits at that time.
Okay. Ma'am, could you please raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Ma'am, if you could have a seat right here, be careful to step. Once you've made yourself comfortable, you can take your mask off if you wish to, or you can leave your mask on if you want to. Just make sure you clearly enunciate so everyone can hear you.
Excuse me.
Ms. Gionet, please state your full name for the record.
My name is Susanne Gionet.
And if you can, just for purposes of today's setting, speak to the judge as to your feelings about your son here today.
Judge Blake, I thank you for hearing me out. I love my son. I raised him to love people and interact with people and be honest. And he's been a delight. And God bless him, he has 6 sisters and 5 of them adopted. And he's always enjoyed interaction with people. He's also always enjoyed making films from a young age. And he's never been in trouble with the law before this time. And I really would like him to look forward to his future. We talk every day. He wants to make an impact for good in the world. And we taught him that, and we support that. And with his misdemeanor charge, I just would like fairness with how we go forward, and to know that he's a human. And I saw him interacting with Mr. Pecora coming in. They seem congenial to each other. He wants to move forward, and we care for him dearly as a family. Him, his brother, he talks to his brother frequently, and we're a family. This impacts a lot, and we care for him and enjoy him and his characteristics that we want him to use for good. That day at the bar, he was there drinking water, supporting his friends, and got surprised. And he was getting thrown out, and he's talking back and forth like that's his strength, to talk back and forth with people. It got out of hand. He got traumatized. And I know from just studying about people, I'm a nurse, I'm also a counselor in training, that trauma, when it happens, it doesn't go away right away. And The Body Keeps a Score was a well-known novel by Dr. Van der Kolk. It takes time to work through the process. And no, he's working through this process. He's going to do what he needs to do as we've taught him, and he's going to keep looking forward. And I just want you to know that he's not just someone that doesn't care about people. He does care about people, and we care about him. And I thank you for the time.
Any other questions?
No, Your Honor.
Cross?
There you are.
Okay. Thank you, ma'am.
That's all for defense, Your Honor.
Pardon?
The defense has no further witnesses.
Okay. Now time set for sentencing. State.
Thank you, Your Honor. Your Honor, this case is about Anthime Gionet being desperate for attention and his willingness to engage in extreme criminal behavior in order to garner views on the internet. The defendant was found guilty by this court of assault for causing physical injury, disorderly conduct for seriously disruptive behavior, and for criminal trespass. For counts 1 and 2, the defendant could receive confinement of up to 6 months, fines up to $2,500, and probation for up to 3 years. For count 3, the defendant could receive confinement up to 30 days, a fine up to $500, and probation of up to 1 year. The state recommends the maximum jail sentence of 6 months jail time and flat time for the defendant on counts 1 and 2, and the maximum jail sentence of 30 days jail for the defendant on count 3. And for these jail sentences to run concurrent with no work release or work furlough. Now, the state understands the recommended sentence is substantial, but the state contends it is the only appropriate sentence for the defendant in this case. For the purposes of determining an appropriate sentence, the state contends that the court should apply the sentencing principles to this particular defendant. Sentencing principles include 1, retribution or punishment for the criminal actions taken by the defendant. 2, specific deterrence. What sentence will send the message to this defendant that engaging in criminal conduct will result in consequences? 3, rehabilitation. Is it possible to craft a sentence that allows the defendant to return as a productive member of society? 4, general deterrence. What sentence will send the message to the public that this type of behavior will be met with consequences? 5, protection of society. What sentence will provide for protection for the public? The state has also provided the court with a sentencing memorandum which goes through aggravating factors, which the state encourages the court to consider, along with the state's analysis of the federal sentencing principles to include mendacity. So let's start off with sentencing principle number 1, punishment for the criminal actions of the defendant. The assault the defendant committed upon Kevin Pecora was severe. He sprayed Kevin Pecora in the face and eyes 2 times with pepper gel, a dangerous instrument. Pepper gel is more dangerous than pepper spray, and pepper spray has been found by other jurisdictions to be capable of causing serious physical injury. Serious physical injury includes the impairment of function or bodily organ, and it's clear in this case that Kevin Pecora experienced impairment of his vision to the point where he had to leave work. He had to go to the hospital. he had to be treated. Mr. Kapoor also explained that he has continued to have eye discomfort as a result of being pepper gel. The only sentence that is an appropriate punishment for the defendant is 6 months jail. So sentencing principle number 2, specific deterrence. What sentence will deter this defendant from engaging in this conduct in the future? The defendant is a self-described live streamer who has a history of antagonizing individuals by filming them when they don't want to be filmed and are engaging in extreme behavior and then pepper gelling them in order to satisfy his viewers on the internet. The defendant self-describes himself as having yoga energy with the whole like pissing people off. And I want to play sentencing exhibit, clip 1.
He's epic. I mean, he's he reminds me a lot of Sam Hyde, obviously. He's got a little bit of yoga energy with the whole like pissing people off, you know, so he's a good.
I want to play state sentencing exhibit 2.
Rush to the restaurant, LMAO.
Here first, the pepper gel is content spray.
Yeah.
I need to get my own.
See this? This right here. This is called content spray.
Is there a difference between mace and pepper spray, or is that the same? Pepper spray?
Yeah, it's a little different. So this is pepper gel. So like this sticks to your eyelids and it doesn't splash back. If you have actual pepper spray, it can like, you can spray someone and it can literally splash back in your eyes. So the gel is much superior.
And what is mace?
I am not an expert on it, I don't really know. But then there's also like bear spray.
You are a little bit of an expert on it.
I mean, Ben received it. I received it, yeah. Well, the advice I will give someone, if you get seriously sprayed like I did, you should immediately go to a hospital and then they just flush your eyes for like an hour. They have the saline solution and you lay down and they flush your eyes. Oh. And then the doctor just tells you to like rotate your eyes. It hurts so bad. But that's the only thing that actually works. Because everyone's like, use milk, use this, like everyone had their own little secret, nothing worked except actually going to the hospital, like to the ER. So, like if you have a severe spray like mine, like some people with a normal pepper spray, they're fine, just you gotta flush your eyes out though. It really hurts though. Most painful thing. I remember when you came back to the hotel, and your eyes were like, dude, you couldn't see anything. Well, my eyes were so damaged, like they would pus would constantly fall out, and like my eyes could barely open. It was brutal. Well, I never met you before. The first thing you saw me is after I got sprayed. Yeah, you came to the hotel. Yeah, you were dirtying out a little bit. I was dirtying out.
The defendant, understanding how painful an experience pepper gel can be, sprayed the victim 2 times in the eyes. He refers to it as content spray because putting others in extreme pain is worth the perceived notoriety that he gets from his radical viewers. Now, on or about October 27, 2020, a little over a month before this incident, the defendant engaged in similar conduct to this case when he started to film a man on the streets. The man informed the defendant that he didn't want to be filmed. The defendant then followed him down the street, continuing to film him until the defendant ultimately pepper gelled this man. I'm going to play sentencing video 2.
Check, yes. New magic check. Okay, here we go towards the music. Kind of crazy, small world. Woo! Lambo check. Let's go find contact, boys. Hey. Hey, what's going on, ladies? Happy birthday! How old are you? 27. Very good age, great age. What are you guys doing tonight? What are you getting into? You guys off the goop. You lit. Get litty. Litty like a titty. All right. The birthday party. Stop, turn around. What's up, dude? Hey, I like that chain. What's going on, dude? I'm in YouTube. I'm in YouTube. I'm not filming you. I'm filming myself. Damn, bro. Stop it. I'm not filming you. No, I'm not. It's a public street, dude. Stop. Stop it, bro. I'm not filming you. I'm not filming you. No, I'm filming. I'm allowed to film, bro. Shut the fuck up. Stop. Stop. Get out of my face. Get out of my face. No, I'm not. We're on a public street, dude. We're on a public street. Get out. Get out of my face. I asked you last time. Get the fuck out of here, bro. Get the fuck out of here, bro. Get the fuck out of my face, bro. Yeah, he's attacking me. Who's attacking me?
Incite, get a response, pepper gel. Content creator for his audience. The defendant also engaged in similar conduct when he approached another individual and filmed her. She then asked him not to film, and he continued to film to the point where she began to walk after him as he ran away. The defendant then reapproaches this individual and pepper gels this individual. State sentencing video number 3.
How's your night going? What? How's your night going, ma'am? How's your night going, ma'am? You tell me to shut up? What? Whoa! What? What? What are you doing? What are you doing? Step back. Step the fuck back. What the fuck are you doing, dude? Stop chasing me.
Gotcha. $3. What?
Yeah, get the fuck out of here. Fuck you.
Now, the defendant profits off engaging in this extreme behavior. People view these videos and they pay him. Look at sentencing exhibit number 14. This is a retweet by the defendant where he ultimately asked for money for his defense fund for this case. The court were to just impose a fine in this case, it would amount to nothing more than a business expense for the defendant. Just look at how fast his $3,000 bond was paid in this case by a third party. A fine would have zero deterring effect on this defendant. The defendant also currently resides in Florida. Placing the defendant on a period of unsupervised probation would have no deterring effect on his conduct. The defendant has demonstrated that orders from this court have no effect on him. Just look at this tweet right here, where the defendant refers to this court's ruling as total BS. Also see sentencing exhibit 13. Another tweet where the defendant says our justice system is dead and to fuck this gay ass country. The defendant failed to follow his own initial release conditions in this case that are set by this court. When he left Arizona without the court's permission and raided the United States Capitol on January 6th of 2020 and then live streamed his crimes. During the live stream, the defendant degraded a law enforcement officer by stating, "You're a fucking oath breaker, you piece of shit. Fuck you." Approximately 4 times, and you broke your oath to the Constitution. See sentencing exhibits 8. This is his federal complaint. The statement of facts which details what he did, which he live streamed.
I'm going to object to all of this extrinsic stuff that the state tried to get in during the trial and was not allowed to, and really has no bearing on this setting at all.
Okay, I'll rule. You may continue.
Also, while on release under conditions to remain law-abiding, the defendant criminally damaged a Chanukah display of Rabbi Levi Levardo of the Chabad of Arizona while in Phoenix, Arizona. See Sentencing Exhibit 11, which is the complaint from this incident. The only sentence that will have any chance of deterring this defendant from engaging in criminal conduct in the future is 6 months jail. Sentencing principle number 3, rehabilitation. Is it possible to craft a sentence that allows the defendant to return as a productive member of society? Your Honor, the defendant is lost. The persona that's created by the defendant may or may not be real, but it creates real dangers for our society. The defendant's willing to do anything, even go to the lengths of harming others in order to garner that attention that he craves. He'll do anything to affirm his belief that he's a public figure or that he's well known. History has shown us how dangerous individuals like the defendant are. The defendant has gone to extreme lengths in order to garner and gain notoriety. Psychological counseling would be helpful for the defendant if he were capable of admitting that he actually had a problem. But the defendant is so tied up in what he has become at this point that the only way to get the defendant to a path where he can be rehabilitated is by showing him the consequences that he will face if he continues down this path. I have some sentencing videos that demonstrate the defendant's lack of a rehabilitative potential. State Sentencing Exhibit 4.
So,
It's just noise.
Yeah,
but no, shit, no, I'm not good. Hey, can we actually talk about this? Can we actually talk about this? Let's actually talk about this.
You want to go beta surrounding the alpha. Beta surround the alpha.
No, we just, we're
Surround the alpha. Beta surround you. Beta.
No, look.
Surround you,
Hey,
beta.
let me be real when we talk. So shut the fuck up, please. I seriously was trying to give everyone here a chance. I know there's little beef. Oh shit, can you just let me talk?
Stop using your estrogen. Stop drinking kombucha. Too much estrogen. Stop
You're not allowed to.
There's too much estrogen in your mace. There's too much estrogen in your mace.
You're not allowed to come to the house.
I don't give a fuck about your
Yeah, you do. You said.
I do not give a fuck about you, you fucking clock monster.
Stop it! Stop it! Stop it! Hey! Fuck out of here! Stop it! Walking me.
Hey, you cannot do that.
Yes, I can. You cannot push people. Yes, you are that.
You cannot do that.
Yes, I can.
You can't punch people, dude. You cannot punch people.
Yes, I can. I can fucking punch that faggot.
No, you can't punch people, dude.
I can. Watch it. Watch it. No, I don't care about you. I can fucking punch you.
Don't be violent.
He's touching people. He's a fucking pedophile. He's a fucking creep. He will be touching people. Yes, he will. Yes, he is. He's fucking Alice, dude. You know. You're covering up for his crime. No, I'm not. I love your script. We're gonna put a great actor, good script. You have to fucking.
State Sentencing Exhibit 5, a tweet that was retweeted by the defendant where he states he misses when Yoba, referring to himself, was free, when he can content spray a nibba because he felt like it. State Sentencing Exhibit 6. Here in Scottsdale, Arizona.
Have you taken the max? Was it your friend over here looking in? But yeah, see, he's trying 5. No chance. Why are you such a fucking prick? Why are you such a fucking asshole? Like what's your deal? Okay, well, what do you got going on today? What do you got going on today? Can I tell you a joke? Okay, yeah, let me tell you a joke. Black lives don't matter. Fuck you, you're gay, you're cringe. Have fun at your fucking pool party. BLM sucks, you're gay, you're fucking gay. Have a nice day. Alright. No chance. No good. This guy's on a fucking power trip. Holy shit. This guy's on a fucking power trip, dude. He's trying to stop whiteboard summer. What's his problem, dude? Huh? I can come back if I want to. It's up to me. Did you see that, dude? They're canceling White Boy Summer. What are you doing? I'm just trying to go to the Blue Fire vlogging. Are you an asshole? No, of course not. I was literally just walking in. You can ask my friend. We're walking in. Like, get out of here. Yeah, we're just trying to go to the pool. Kind of fucked up, but hey, White Boy Summer, bro. Let's go. Yeah. Hell yeah. All right.
State sentencing exhibit 7.
Different sins
Well,
from another.
I mean,
And also,
I wouldn't say they're all equal. So you're
They
saying?
are all equal.
No, they're not. If I murder you right now, if I shoot someone in the face, that's the same as like,
Is he dead hurting anyone?
yeah,
How?
because you're influencing little kids that, you know, are getting hormones when they're. And you guys are fake Christians. Fake. You guys are. You're a witch. You're in a new age bullshit, dude. Look at you. Yikes. You look like Kingdom Hearts characters with those goofy ass pants, girl. Fucking lesbians. Beta! Little dykes. Yeah, Jesus loves you, but you got the wrong. You are not even following the Bible. You guys are gay. Woo! What the? These guys are gay. What the?
Your Honor, these videos also support the state's request in our memorandum that you find the defendant committed the crimes out of malice towards the victim, out of the defendant's perception that the victim belonged to a certain identity group. Specifically, the defendant referred to the victim as being a little faggot and stated that gay people suck.
Let me ask you about that, since I wrote that law and lobbied for it.
Yes, sir.
It's meant to go after people who actually have a hatred for groups. Your argument seems to be he's a phony, doesn't have hatred for groups, and uses this just to get money and publicity. Isn't it?
That's one way that I don't know what he is, but all I know is what his actions are repeatedly over time. So it seems to be that this is his perception that these are either gay people that he's engaging in this type of conduct with, or we just all black people. So, and in our incident, I mean, he refers to the victim as being a little faggot, and gay people suck immediately before.
Sure, but I thought you were saying he does these things in order to just generate, I don't know what they call it, but generate viewers.
Yeah, he does, I know that he does these things.
Right.
Does he do these things because he is indeed? I can't tell you that, Judge, because I think only he knows that.
Right.
But all I know is he's got a pattern
That
of
would be
doing it.
necessary for it to be an aggravating circumstance.
Well, it seems like that he is doing this to people that, based on his perception, fit within these groups.
Well, let me give you an example in the case we have here. Do you really think he thought the victim in this case was gay?
I don't know what he thought, Your Honor. I don't.
Was that your argument?
That's not my argument,
Okay.
Judge. And so, I'll move on.
Sure, go ahead.
But for a person to have rehabilitative potential, they have to first admit that they've done something wrong. The defendant has shown no remorse for his actions. Instead, he's doubled down on misrepresentations that he was the victim and that he had to engage in self-defense. See sentencing exhibits, well, we already saw the tweets in 13 and 14, but see sentencing exhibit 12, a video that he made not too long ago here in December.
Okay, so January 13th is my next court date. That's gonna be, in Arizona, which, dude, I'm sick of paying for flights. Like, I don't have any money, dude. I'm sick of paying for flights to Arizona and all this stuff. So that one is wrapping up. That's the sentencing. You know, I got guilty on all charges, but we're doing the sentencing, and right then and there, my attorney's gonna say, all right, Judge, we are filing the appeal. We are appealing this case. So we're gonna be fighting that in the appeals court. We'll be filing that on January 13th, right after the sentencing. And then the way it works is the sentencing will be on a stay or on hold. So even if they were like, you need to do a week in jail, we're gonna say, try me, bitch. we're appealing. So they can't actually force me to serve whatever sentence they give. I don't even think it'll be jail time, but these motherfuckers are literally attacking me for saying faggot or being not supporting LGBT and all this shit. That's the main thing.
Defendant, that's not somebody that's showing remorse for their actions. Additionally, the state asked the court to find the defendant made willful and materially false representations to this court during his testimony as provided in our sentencing memorandum. And this shows lack of rehabilitative potential. The state asked this court make the finding on the record and note that it was considered in crafting an appropriate sentence for this case. Finally, the state became aware today that the defendant used his Telegram social media account and posted to a chat group right after his conviction with the prosecutor's contact information and said, this faggot is the prosecutor, by the way. Sentencing exhibit number 15. The defendant has no rehabilitative potential at this point in time, Your Honor, and the only appropriate sentence is 6 months jail to send a message, to give him a chance to realize that his actions are going to have consequences to get him to a point where he can be rehabilitated. Sentencing principle number 4, general deterrence. The defendant has indeed gained an extremist following through his live streaming. The court just needs to look at some of the motions that were filed in this case by third parties to realize, or just read the comments posted on some of these videos by his followers and to his live streams to understand it.
Why is he responsible for that?
What's that?
Why is he responsible for that?
Well, one of the sentencing principles is general deterrence. So I'm just drawing out that the sentence in this case could have a general deterring effect. And so what I'm saying is that if this court leaves the defendant's criminal conduct unpunished, that it could fuel others to engage in this similar type of conduct. That's why a serious enough sentence is needed in this case in order to, like I said earlier, to deter the defendant, but also to deter others from engaging in this.
Well, I understand that argument, but he is not responsible for what other people do.
I'm not saying he is, but what he's doing fuels other people, and he has people that follow him. And I'm saying that an appropriate sentence in this case could deter others from engaging in this type of similar conduct. That's all I'm trying to say.
Sure.
Sentencing principle number 5, protection of society. Sentencing exhibit number 9.
Hell yeah! Let's go! Dude, we're in the Capitol right now.
Underscore sign.
Occupy the Capitol, let's go! We ain't leaving this bitch! I'm sleeping in this room. I call this chair. Occupy the Capitol. Patriots are in control, baby. Yes. I told you. I told you. What are they doing out here? Wait, what is that rope? Are they kind of put a flag on? Are they putting a flag on? Oh, we put a flag out. That's a banner. That's what's up. For some reason, oh, yeah. Yeah, look at that. So all the cops are outside. We're. I'm the whole U.S. Senate right here.
Christ is king.
Yeah, get Mike Pence on the phone. All right, let's continue to tour the Capitol. It's a nice tour. Don't talk about the office. I saw a couple ballots in there, yeah. I did. It'll probably take a couple months to count. Yeah. Hello, police department. Let's go. Any other rooms? Oh! Let's check. Hey, it's a busy one. Hey, we're getting a nice tour of the Capitol. Let's go. Yeah, I want to see them. Oh, wow. This is a nice one. Yeah, don't destroy everything. Yeah, we're in our house. We don't need to, don't break anything. Just enjoy your time here in your house. You know? Put your feet up, you know? Relax for a little bit. Yeah, thank you. Let's go. All right, our house. Whose house? Whose house? Whose house? Whose house? Whose house? Let's go. Oh, wow. Look at this view, guys. Wait. Whoa. Yo. This is fucking awesome. This is crazy. So the cops are on, and we're in here. Hey, someone. Just ridiculous. I can't even see the viewer count, so let's go. This is wild, bro.
Your Honor, society needs to be protected from the defendant, and the only appropriate sentence is 6 months jail. When you look at all these sentencing principles, when you consider our memorandum, the state asks that you impose 6 months jail for the defendant. Thank you.
Do you or your client or both wish to address the court prior to sentencing?
Yes, Your Honor.
Go ahead.
Thank you, Your Honor. In regards to Mr. Gionet, I believe this court's aware, but if not, Mr. Gionet has no criminal history whatsoever, Your Honor. He's 34 years old, and this would be his first run-in with the law. Now, in regards to a request that he be given special treatment because this is the first time he's ever gotten in trouble, that's not what the defense is saying. But what I am saying is that what's happening here today in terms of the request for 6 months of jail is unprecedented in terms of my experience with the law and any time I've ever had any interactions with defendants in Scottsdale whatsoever. In fact, it was probably a couple years ago, I had a case where I was trying to get my client into a certain position, and I sent an email to Jared, Mr. Austin's counterpart. And Jared's response to me was, we're not going to do that, we try to treat everybody the same. That's not what's happening here today. From the beginning of this case, from the inception, it was obvious that they're not treating Mr. Gionet the same as every other defendant that's come along. In fact, I'm sure it's happened, Your Honor. I take no umbrage that a person has been sentenced to jail on a first-time misdemeanor or first-time misdemeanors. Obviously, we know that happens with DUIs. But I personally have never experienced a jail sentence for someone who has first-time DUI or first-time misdemeanors. I have not experienced that here in Scottsdale, nor have I experienced that in any other court I've practiced in. And I've practiced in courts from all four corners of the state. So the request today, from our perspective, is very abnormal, and very much so that there's a showing that they're not treating Mr. Gionet the same that they treat every other defendant that comes through their office.
Let me ask you about that. I agree it's unusual, but you've never seen like the sex offenders get jailed the first time in city court?
Maybe I just haven't had sex offenders
Okay.
for municipal. Most all of that I've dealt with is in felony court, but
I agree with you, it's unusual, but I have seen it happen with sex offenders, with people commit acts of violence, that type of thing.
okay.
But go ahead.
Yeah, no, thank you, Your Honor, and I appreciate that because obviously we're not here for a sex offense, and in terms of this being a violent offense, I want to just kind of go over a few of the points or what the state believes are aggravating factors in this case and the defense's position on those. In regards to the aggravator one, the state admits that they're unable to find any case law that this is serious physical injury. And being in the position that I am, having defended felony cases for aggravated assault, I believe there's a reason why the state's unable to find any case law on that. And that's because this isn't defined as serious physical injury from my perspective. I know the state feels differently. But if this was, given the malice that it appears the state has for Mr. Gionet, they certainly could have submitted this to the Superior Court for aggravated felony charges. But I don't believe it's there. I believe that this is a stretch, that the fact that they're asking that it be considered serious physical injury. The fact is, we know that the mace or the pepper spray is washed out with milk. It's not something that leaves a scar or a mark on a person for the rest of their lives. It's not, and for instance, one of the felony ag assault cases they had is someone had gauges in their ears and one of the gauges got ripped out and the ear was hanging down. So, I mean, this isn't that type of an injury.
Can I ask you, what's a gauge?
Oh, I'm sorry, Your Honor. That's where people put the things in their ears that expand their ears out.
Okay, I know what you're talking about. Go ahead.
Yeah, sorry.
Sure.
And then, so the aggravator 2 that the state's listed, essentially, I don't want to say disappears, but if there's no serious physical injury, then it's not a dangerous instrument. I mean, that's the definition, as the state even puts it in their own sentencing memorandum, that a dangerous instrument is capable of causing a serious physical injury. I believe a gun is capable of causing a serious physical injury, a knife, maybe brass knuckles, but I don't think pepper spray or mace is that. We heard the state talk about evidence that, or their belief that Mr. Gionet committed this as a hate crime. And I think the court addressed that respectfully. I don't think that there's any indication whatsoever that came out during the trial that Mr. Gionet believed that Mr. Pecora was or was not gay. And I don't think that his interactions with him were based upon that. Additionally, and I don't believe that Mr. Pecora at any time said that he was, or that he felt like that he was gay, or that he felt like that this whole interaction took place because he was gay or straight or any of the above. I mentioned that this case has been something that the state and the city of Scottsdale, in regards to the prosecutor's office, appears to have taken a special desire to see Mr. Gionet punished. And so I want to reflect back to the bond hearing that we had, in which the state asked for, and again, this was unprecedented. I've never had the state ask for a $35,000 bond in any misdemeanor case I've ever been on. There's been a lot of firsts in this case, Your Honor, at least for me. And the court disagreed with that request at that time. But what it demonstrates is how differently Mr. Gionet has been treated throughout the process and throughout the course of this case. It's further demonstrated when we got into trial, and the prosecutor wanted to continuously play videos that were extrinsic, had no relation to this case at all, and I had to continue to object repeatedly to all of those videos that had nothing to do with this case. So what he did was he then brought them to this hearing, knowing that the rules of evidence are relaxed and he can play whatever he wanted to. The whole purpose for all of that was to try to smear Mr. Gionet as much as possible. The fact of the matter is that some of these things that were posted up here today, there is no evidence that Mr. Gionet made these certain posts or the foundation for these things. And in regards to the actual assault that Mr. Gionet was found guilty to, I want to touch on that because, and respectfully, I don't wish to put words in the court's mouth, so please bear with me. But I think that when you passed a sentence in regards to the assault, you had mentioned that in regards to that first spray, that it was generally that, again, forgive me if I'm not trying to put words in the court's mouth, but that first spray was warranted based upon him being shoved.
Yeah, that would not be a correct interpretation. What I was saying is I understand the argument as to why that could be self-defense.
Okay.
I didn't understand any argument as to why the second one was.
Okay.
Whether I understand an argument or not isn't necessarily the same as me agreeing with it.
Okay, Your Honor, fair enough.
But I do remember what you're talking about, and I understand that.
Okay, and so I think the court understands what I'm getting at, which is that the transition from a verbal confrontation to a physical confrontation, whether it can be expected or not, based upon whether or not those are fighting words or what have you, it's an escalation. And so I don't think there's any dispute as to who became physical first. But that reaction by Mr. Gionet, while the court has determined was unwarranted, at least definitely for the second spray, was a reaction to the physical interaction that then took place once he was shoved. And I don't think there's any dispute that in that video, it's very clear. We didn't see it again today. We watched it many times during the course of the trial, but I don't think there's any dispute as to the strength of that shove. It was a very hard shove. It wasn't a tap. It wasn't a poke. It was, I'm going to knock you on your ass type of shove. And Mr. Gionet did react to that, but I don't think that, I don't believe that the picture the state wants to paint, that Mr. Gionet was just itching to pull out his mace and hose Mr. Pecora down, is the case. I think if he had wanted to do that, he could have done it prior to being shoved or whatever. I mean, and that's not what happened. So the fact of the matter is that was a reaction. Whether it was warranted or not is something that's been decided. But that was a reaction. It wasn't something that was done for clicks or for his personal gratification. I think in regards to all of the extrinsic videos that we've seen today, all of the other stuff that the state wanted to put before the court today, it continues to paint this narrative that the state wants to see him punished for other acts that had nothing to do with this case at all. The state repeatedly said, well, how are we going to show that, or how is he ever going to learn his lesson? Well, I could understand that argument if this was his 4th, 5th, 6th misdemeanor that he had gotten and he was not learning his lesson. I mean, in fact, when I talk to my clients and I explain the maximum, I explain, hey, this is for the worst of the worst. That's why it is the maximum. That's for people who aren't getting it. That's for people who have repeatedly had to go before the court because they go back into society and then they reoffend again, whether it's a misdemeanor or otherwise. And that's not what we have here today. In fact, the court is aware, I believe, that Mr. Gionet has federal charges. He has been on probation in that federal case for over a year. He's been on probation. And this is the kind of probation where if he messes up even slightly, they will throw him into federal custody. And so for over a year, he has, and since the inception of this case, has maintained good behavior. And so
Judge, I would object to that. I believe he's had 4 potential, or few at least, potential probation violations.
That's
that
incorrect.
are alleged that they had hearings, like he didn't notify the court that he moved to Florida, for instance.
Okay, but go ahead with your argument.
Thank you, Your Honor. That's absolutely incorrect. If he had violated, I can assure the court that he would be in federal custody. They've made that clear that they're not accepting really even minor mistakes in these cases. So, and Mr. Gionet is not in custody. He's here with us, and that's because he has not gotten into any further trouble or any further law enforcement interactions in which he would be finding himself in trouble.
Let me ask you so I can clarify. I wasn't aware he had been convicted.
He's not. He hasn't.
Then how's he on probation if he hasn't been convicted?
It's a pretrial probation. It's
It's
like
release conditions. He's on release conditions.
he is on release conditions, but he has a PO for his felony case.
Well,
I
they
mean,
have
for- I'm
supervised
sorry.
release here in Superior Court too, but I mean, probation is you're convicted in order to do things over a period of time by a judge. So he hasn't been convicted. You're not saying that.
No, I'm not saying that. Your Honor.
Okay. I just wanted to clarify that because I wasn't aware he had been convicted of anything.
Yeah, no, he is not, Your Honor.
Okay.
And so maybe my terminology needs to be tweaked, but essentially he has a probation officer that he has to report to. And he keeps in constant contact with. He has for over a year. In fact, when all of this, when that case started, his probation officer would go visit him at his home. There was home checks. It's not a unsupervised type of thing where he runs around and does whatever he wants. He's there. They have watched over him diligently, and he has maintained good behavior throughout the course of that, and since the inception of this case. I think, again, as I mentioned, what I see is the state seeking to treat Mr. Gionet differently than any other defendant I've ever represented before this court or any of the other courts in Scottsdale. And it seems to me obvious that they want to punish him for acts that have no bearing on this case at all. I think that given that the victim himself came before this court and asked for no jail is significant. And it's also significant in the way that it shows, again, the distinction that I'm making with how Mr. Gionet is being treated. Because instead of listening to the victim, the state is saying, no, we're not going to give him no jail or recommend no jail. We're not going to go with what you've asked us to do. We're going to go for the max. And again, I don't often see where the state deviates from what the victim wants or what the victim asks for. And especially so in such a way that it's 0 jail to the entire max, the maximum of punishable by statute. Your Honor, I would submit that Mr. Gionet, as you're aware at the beginning of this proceeding today, he stipulated to paying restitution. He intends to pay that in full right away, and he is still remaining on probation. So to the state's fears about whether he's going to learn or if he's a danger to society, he is still on probation and will continue to be on probation. I'm sorry, you know what I'm saying in terms of his probation officer, not.
Correct.
But he still has that check-in that he has with the federal government. So in terms of concerns that he's going to go back into society and act wild or break the law, I don't think that's he knows for him, he knows what that means. If he was to break the law, he's likely looking at going into federal custody. So I think that those concerns are unfounded. I think they're also unfounded, again, I hate to repeat myself, but I think they're also unfounded given that, again, Mr. Gionet, this is his first time being in a courtroom for any violations of the law. For these reasons, Your Honor, and given the fact that the victim himself asks for no jail, I would ask that Mr. Gionet be sentenced to no jail. I think that obviously he's paying restitution. I think that if the court wanted to impose community restitution as well, and a fine, that may be appropriate, but I don't believe that jail in this situation is appropriate. I think that in regards to the specific crimes that he was found guilty of, I know the court determined guilt on all three of the charges. And I think that in regards to the severity of each one of these, I don't believe it rises to the level of 6 months in jail for the assault, 6 months in jail, whether it's concurrent or not, for disorderly conduct. And so for those reasons, Your Honor, we would ask for no jail, as the victim asks, probation if the court would like, but again, Mr. Gionet has a probation officer currently, and as I mentioned, community restitution if the court feels inclined. And that's what we would ask for here today, Your Honor.
Sir, did you want to address the court?
No, Your Honor.
Okay. Having heard the arguments of the parties and weighed the elements, just so you know, the record's clear, the state has asked for bonds much higher in other cases. But as you know, because I didn't impose that bond, I didn't agree with that amount that they were asking for.
Sure.
I think the highest I've ever seen in Scottsdale City Court is $250,000, but that was escalating. The person kept committing crimes and being arrested, and
Yeah.
they weren't stopping, so they kept raising the bond in order for them to stop, or
Right.
which isn't, of course, the case here.
For me, that was the highest I'd ever seen,
Sure.
or seen it, the state request and a misdemeanor case, Your Honor.
Yeah, but I remember that one because I had to take the case over to address it, and because the defense obviously wanted it reduced, but based on the unique circumstances of that case, it wasn't. I would point out that the victim did ask for no jail under circumstances. None of those circumstances have been met, and obviously the one about pepper spraying yourself on TV shouldn't be met.
I'll gladly do it.
That isn't something someone should do. Now, what we have is first the court orders restitution in the amount of $187.10, and that's the copper what?
That was Copper Point Insurance.
Copper Clean, and then restitution in the amount of $613.18 to Giligion's Bar. We have the case here where the only time I know that generally everyone gets 6 months in jail is an extreme DUI .20 with a prior, which is the maximum. I understand the state's argument, but I don't believe the maximum jail time would be appropriate in this type of case. As to the trespass, I think that would be a fine, count 3 would be a fine, $382.20. $82.20. As the counts 1 and 2 are to run concurrent. Now, while I don't believe the state's recommendation of 6 months is appropriate in this case based on what occurred and it being his first time for a conviction, and I think that is something that needs to be considered by the court, that it is his first time for a conviction. I believe jail is appropriate under the circumstances due to the violence that occurred, and there is no need for it. So the question is, how much would be appropriate? And I've gone back and forth as to what I think is appropriate, just even during the arguments. Because at one point I was thinking 60 days, then at another point during the presentation I was thinking 90 days. But having heard the arguments and weighed the arguments of both parties, I think a 30-day sentence would be appropriate, because it is his first time, and because hopefully if that doesn't convince someone to maybe mend their ways, I'm not sure what else will. But as the events continue escalating, and I certainly hope they don't, I certainly hope this takes care of that, then another court could impose what they think is appropriate. But because this is the person's first time, obviously from what I've said, I don't think the maximum is appropriate. And I think 30 days, if that doesn't get someone's attention, I don't know what will. And then they'll have to deal with whatever consequences are for them. And jail costs for 30 days would be?
3210, 12.
Pardon?
3210, 12.
$3,210.12. Okay. Insert, as you said in your video, you have the absolute right to appeal. You'll be given your appeal rights, and that will stay the sentence pending the appeal. And so that the higher up court can review what I did and decide whether they think it's appropriate or not. Do you have any questions, sir?
No, Your Honor. Thank you.
Thank you very much.
Your Honor, would you prefer that, so I have the notice of appeal now, would you prefer that I file it in here or take it to
To the windows, because they're using it to do all that.
Okay.
Okay, if there's nothing else, we'll be in recess. Thank you very much.
Your Honor,
Sure.
in regards to the jail, is he gonna be, picking a date and then
You
self-surrendering?
pick a date, but just it immediately stops when you file the appeal. So you can pick any date you want.
Okay.
It's going to be stayed pending the appeal.
Okay,
Everything's stayed pending the appeal.
understood.
Except I think restitution. I think they still collect that, but they keep it in a special account till there's a decision.
Okay,
But yeah, just because the computer requires a date to be picked, but just pick a date 30 to 60 days out and it'll all be stayed once the appeal is filed.
okay, thank you.
Thank you all.
I feel like, I don't know, cancer patients are like the worst of the worst. Like, they always want people to feel bad for them. Like, I'm supposed to give a shit because you have cancer, bro? Like, get over it, bro. You know? Get some Windex. Scrape it off. Clean your face. I don't know, dude. I mean, I'll pray for you, bro, but, no.
You're triggered.
This guy's yelling. He's like, "You're triggered! Ah, you're triggered!" I'm a real man! I'm a real American! I have to scream because your Jew mouth won't stop talking. Your Jew mouth won't stop talking.
Satanist or a Jew?
Your Jew mouth won't stop. Yeah, it's the Satanist and Jew is the same thing.
Okay, funny.
Yeah. What? You triggered?
Still victory. They thought we wouldn't stand up. Guess what? We're standing up for our rights. We're proud to be white. We're proud to be white, brother. Proud to be white. We're proud to be white. Hail victory. Hell yeah. Thank you. Love you guys. Hail victory. White lives matter. White lives matter. White lives matter. White lives matter. Hell yeah. White lives matter. White lives matter.
Someone wanted me to say the 14 words, so of course I'll say the 14 words. We must secure the existence of our people and a future for white children. Hey.
With me. Baked Alaska, I honor you for your courage in this event too.
I love you, Dr.
Now
Duke.
listen,
Thank
when
you
we
so
get
much.
back to the park, well, we love you too. We really respect.
Far-right social media personality Tim Gionet, who calls himself Baked Alaska, is facing new misdemeanor charges. He's accused of damaging a Hanukkah display outside the Arizona Capitol in December of last year. Prosecutors declined to provide specifics on the charges, but one of the people who helped organize the display in Wesley Boland Plaza said a video shows Gionet tearing off a sign. Gionet has not yet entered a plea. He's also facing charges in connection to the January 6th riot.
I can call the U.S. Senate, apparently. Okay. Hello. Hello, U.S. Senate. Yes, we have. Yeah, we need to get our boy Donald J. Trump into office. Yeah, can we do that real quick? Oh, yeah. Oh, thank you. Thank you. Let's go. And it's yoga season. Yoga season. Let's go. Okay. America first is inevitable. Let's go. Fuck globalists. Let's go. Hey, don't sub me, bro. No, don't sub me. You're not allowed to sub me. Hey, you're cool. Dude, don't. I'm going. Stop shoving me. No, you got a fucking problem. You're a fucking oath breaker, you piece of shit. Fuck you. Fuck you. Fuck you. You piece of shit. You broke your oath to the Constitution. Fuck you. Fucking shoving me and shit for no reason. What the fuck? These fucking oath. Yeah, don't talk to cops. True.
Dropping my pennies for you right
People,
now.
baby. We the people. We are the storm. We are the storm. We are the Kraken. Unleash the Kraken. Unleash the Kraken. We are the storm. We're taking our country back. Trust the fucking plan, baby.
Yo, Baked Alaska, right?
Let's go. Yoba. Yoba 1776. Alright, you got pepper spray.
Everybody that's outside, tell them to get in here now.
Are you doing better?
No, I hurt my cow.
I'm sorry.
They shot me in the eyes twice.
You're a hero, buddy. We got people on live stream praying for you right now, bro.
Thank you. God bless you.
You're a hero. We need people standing up.
This is our country.
That's right.
We need to reclaim it.
That's right.
We're not going to let the globalists take our country.
No, this is
America.
And for God's truth.
Everybody, if you're seeing this, come down here now. We're not backing away. This is our house.
That's right.
Police are traitors. Police are traitors. Police are traitors.
Police are traitors.
Police are traitors.
We hate our cops. We hate them now. We hate our cops, our law enforcement. We hate them because they're not important. Something like that.
Let me tell you, these are the real type of Proud Boys. 1488 type Proud Boys. Proud to be white Proud Boys.
Goddamn right.
These aren't faggots.
No Marxism. White power.
These aren't faggots.
14 words, sir.
We must secure the existence of our people and a future for white children.
Woo! Hell yeah.
Hitler did nothing wrong. Hitler did absolutely nothing wrong.
She thought Tony was gay. Ask her if she's burned the coal. I think that means got with a black dude.
1488, Hitler did nothing wrong.
So you've never been with a black guy?
Oh, I gotta hit the port.
Hey. Open it up.
Fuck Muhammad. Fuck your false prophet. Fuck him.
Yeah, when I get 10,000 subscribers on YouTube, I'm putting out new music.
They're trying to charge me with trespassing and disorderly conduct.
So you've got trespassing, you've got disorderly conduct.
Yeah.
Anything else?
And now the feds are threatening to slap me with a felony if I don't cooperate with them, and I'm not even sure what that really means. And that would be for obstruction of Congress, which is absolutely bogus.
So just so that I understand clearly and so that people understand at home, they're saying that if you don't cooperate with the investigation, meaning you don't become an informant, meaning you don't give the names of the people that you were with, meaning you don't assist them in jailing other Trump supporters, that they're going to add charges if you don't cooperate.
That's right, a felony, and that's an 8-year
and that was an
charge.
explicit threat from the
Yes,
FBI.
that's received by my attorney.
What did your attorney say when he told you that?
It's just kind of, scared the hell out of us.
I bet it did. You told me earlier that the FBI said they would add additional charges if you didn't become an informant, if you didn't help them. Did you plan to do that?
I don't plan to do that.
Did your parents have an opinion on that, whether you should flip, as it were?
I mean, they want me to, not get a felony, of course, but
right.
It's a very tough situation.
Because the other stuff that you're being charged with is misdemeanors, right? So they're dangling a felony which has all kinds of life-altering consequences.
Yep.
Is it fair to say you haven't made a final decision about that yet?
That's fair.
Yeah.
I mean that terrifies me that I even have to consider it. But how else do you
look? I can understand
approach the situation?
I've got friends who wouldn't even consider it.
When I'm on the run, all I gotta do is dial 911. We love our cops, our law enforcement.
Far-right social media personality Tim Gionet, who calls himself Baked Alaska, is facing new misdemeanor charges. He's accused of damaging a Hanukkah display outside the Arizona Capitol in December of last year. Prosecutors declined to provide specifics on the charges, but one of the people who helped organize the display in Wesley Boland Plaza said a video shows Gionet tearing off a sign. Gionet has not yet entered a plea. He's also facing charges in connection to the January 6th riot.
I don't know. I don't want to try. I don't know. Isn't this a public sign or something? Ugh. There we go. No more Happy Hanukkah. Only Merry Christmas. This is a disgrace.
Yo, do you know where the bathroom, the nearest bathroom is?
So my attorney just let me know the U.S. government has just filed new charges against me for allegedly taking a sign off of a menorah. I'm not even fucking joking. This is, I told you, I had cops come to my house and there was a sign that said Happy Hanukkah that I allegedly took down, like a cardboard sign, and then left it on the ground. Didn't take it, just as a joke, and I said, why aren't they saying Merry Christmas anymore? So, fuck, dude. I'm really fucking shocked at this news, and I'm really not excited and not happy. I'm really fucking pissed off, dude. I'm in a terrible mood. Such a good influence. I learned all of my stuff from Bryden, though, honestly. Hey, I don't... Hey, I don't...
He asked the question, and, they responded with a nice Hail Sig.
Hail Sig?
What is it called?
Are you dyslexic? He is dyslexic. Hail Sig.
Dude, I'm sorry I'm not informed on the Nazi,
Well, okay, you watched The Greatest Story Never Told. Okay, but...
He watched the condensed version.
Okay, well, point is, Zeke Heil, you Hollywood Nazis, and I'll jump in Discord here and drink more beers, but
all right.
Thanks, always good seeing you guys, great meeting you there, Mikey.
Later, brother. Arcmedia.org, go there. Hollywood Babylon.
All right, guys, you saw it here first.
Yeah! Woo! Oh, sevens, baby!